Happy to discuss the probate process here in North Carolina. It is different state to state for sure. Generally speaking, we kind of approach it in about 4 phases. So first and foremost, you have to actually get appointed as the executor or the administrator of the estate. We call that the opening phase, where you're filing applications and little preliminary inventories. The clerk of court has a packet of lovely documents that you get to complete to even try to be appointed in that position. Now, if you are appointed into that position, you move on to the next phase, which we call the inventory phase. And that is where you have 90 days from the date of your appointment to get a to-the-penny statement of all of the assets that this person held in their name as of the date of their passing. Needless to say, this process is very front-loaded. That is a lot of information to gather in just 90 days, but we help our clients work through that, focus on what is truly necessary for those filings. But opening phase, inventory phase, and then you have a lovely accounting that you have to do. That's our third phase of the accounting. Every penny of probate assets that comes in and goes out has to be accounted for. And things have to be done in the proper order for the proper purpose. If things are not done in the proper way, the executor, personal representative for the estate can be held personally liable. So that is where a lot of missteps can occur. That is where we make sure our clients know well in advance what's allowed, what's not allowed, what the clerk will need to look into, what you need to ask prior approval for. So again, something, if you've never walked that path before, incredibly important to have counsel on. The fourth phase is kind of what we call the closing phase, winding down, where you're actually making distributions to the beneficiaries, hopefully, if there's assets left after paying off creditors and things like that. So making sure, again, you get the proper receipts, acknowledgments, and that you yourself, as the personal representative for the estate, are protecting yourself. Again, we're always looking at what are the potential liabilities for that personal representative. But yes, closing things down, sending things to the clerk, and hopefully, after some processing time, depending on the county, getting discharged as the representative of the estate. So the executor is the person that is appointed in the last will and testament. Now, it is something worth clarifying. Getting named as an executor in the document in the last will and testament does not mean you are the executor. You still have to go through this whole appointment process with the clerk of court to actually become the executor. Once you are the executor, you then have the power to get information regarding the assets of the deceased. What did they own? What was the value of the asset as of the date of passing? And you have this legal obligation. You are a fiduciary under the law to abide by the terms of the will and make sure the terms of the will are executed properly. Again, this is something we walk our clients through in detail because if you do the wrong thing in the wrong order, you can be held personally liable. So making sure the executor knows, all right, here's what I need to keep track of, here's what I need to do, and here's what the clerk of court is really going to be looking for. Because that's something through this process, gathering information as you go along is so much easier than having the clerk say when you're ready to close things down, oh, I need all this other information that you never got. So prepping our clients that are serving as executors to know, kind of work with the end in sight, know where we're going with things is incredibly important. But yeah, the executor is really the one that's tasked with carrying out the terms of the last will and testament and making sure their loved one's wishes are honored efficiently and effectively. So unfortunately, there are many challenges, many delays that can pop up in probate. Very commonly, there can be creditors that arise, whether it's final medical bills, credit cards, taxes is another thing of a loved one may not have filed taxes for several years. Those are things we want to figure out, hopefully, as soon as possible so that you haven't distributed out assets to others when really the IRS should have been paid first. So that's something as we walk this path with our clients. Creditors, taxes are something we always want to look at, make sure they're paid in the proper order. Then there's also the potential for difficulties with beneficiaries. Relationships are not always the best between executor and a beneficiary. That happens. We can help with those clients for many, many different valid reasons. An executor may not be the best person to communicate with the beneficiary. So we can serve to step in, oftentimes as a little bit of a buffer to say, hey, we represent the executor, the administrator of the estate. We understand you're a beneficiary. You, beneficiary, always have a right to your own counsel. Here's what we're doing on the estate administration side. And just oftentimes, a lot of what we find, these conflicts arise due to lack of communication. So if we can help open up that communication and make it clear there's no malfeasance going on, that can help a lot to kind of smooth the road, avoid litigation. We don't want litigation openly. That tends not to be in anyone's best interest. So yeah, that's, I would say the biggest things are creditors, lack of communication, friction between beneficiaries. That's a big one we can help with. Yeah, so this is a question we get very frequently. Should I hire an attorney? Can I do it myself? And it's a tempting thing to try and DIY because there's these forms, it's meant to be accessible to the public. We do recommend hiring an attorney. I know that's a little biased, but from what I've seen in my day-to-day practice, the value of hiring an attorney is so it greatly outweighs the cost, because essentially we're here to guide our clients and make sure things are done properly the first time around. The biggest thing is our whole goal is to advise our clients and protect them. So again, this is something, if things are done in the improper order or an executor doesn't really realize the information that they should be gathering to start, they can expose themselves to personal liabilities if they had paid out a creditor that they shouldn't have or what have you in the wrong order. Or they can also just cause themselves so much more headache and heartache of not realizing, oh, when I talked to that bank to get a statement of the value of assets in that bank account as of the date of death, I also should have gathered all the statements that have accrued since then. Maximizing our clients' time and effort, knowing again where we're going with this process, what the clerk of court is going to require of you. If you've never walked that path before, you have no idea what you're supposed to be gathering and what the clerk of court is going to want to see. So we really I had a client call us a Sherpa through this process of, we've walked this path many times. We know what paths to avoid, where you need to step so that you are safe through the whole journey. That's a big part of what we do.